The Supreme Court, as by now you know, has a new justice. It's the highest court in the land, takes a big swing to the right in the process. Amy Coney Barrett, she was sworn in last night, but Democrats continued to voice their displeasure right up until she was approved by the Senate. Here's Minority Leader Chuck Schumer speaking up for his caucus both at the process and the rightward tilt.
The American people will never forget this blatant act of bad faith. They will never forget your complete disregard for their voices, for the people standing online right now and voting their choice, not your choice.
But Mitch McConnell, obviously not concerned about how his colleagues across the aisle, or for that matter, if you believe the polls, the American public, viewed the process. Take a listen to the Senate Majority Leader all but rubbing it in.
We made an important contribution to the future of this country. A lot of what we've done over the last 4 years will be undone sooner or later by the next election. They won't be able to do much about this for a long time to come.
The process and the new justice, they're taking a lot of flack. The Washington Post editorial board called the situation, and I quote, the single greatest act of judicial politicization in the modern era. And a piece in USA Today saying few Supreme Court justices have reached the nation's highest bench with as much immediate potential to influence American democracy. Now, even before Justice Coney Barrett was sworn in, the High Court, it made a ruling that could have a major impact on this coming election. In a 5-3 vote along ideological lines, the Supreme Court declined to allow Wisconsin, a pivotal swing state as you know, to count ballots received after Election Day. Mailed before Election Day, but received after. Now, that ruling is considered a decisive victory for President Trump and the GOP, as Trump narrowly won that state in 2016, and this ruling could be a deciding factor this year. Democrats and voting rights groups, they're incensed by the majority decision, as mail-in ballots tend to be heavily Democratic. They're also livid by the rationale of the majority decision as written by Justice Kavanaugh, where he spelled out why states should decide the result by midnight on November 3rd. And I quote, those states want to avoid the chaos and suspicions of impropriety that can ensue if thousands of absentee ballots flown in after Election Day and potentially flip the results of an election. And those states also want to be able to definitively announce the results of an election on election night or as soon as possible thereafter. Justice Elena Kagan, she wrote a stinging dissent, and I read now also a portion of that. Quote, Justice Kavanaugh alleges that suspicions of impropriety will result if absentee ballots flow in after the election day and potentially flip the results of an election. But there are no results to flip until all valid votes are counted, and nothing could be more suspicious or improper than refusing to tally votes once the clock strikes 12 on election night. To suggest otherwise, especially in these fractious times, is to serve the electoral process. I want to bring in our guest, retired U.S. District Court Judge Shira Scheindlin. And, you know, I defer to you on the law, but someone's got to explain to me the logic in the middle of a pandemic when even me, the TV talking head, has been telling my audience that, listen, don't expect to know the results on election night here because particularly because an administration defunded the post office and we're going to have so many mail-in ballots that it's going to take a while. Now, I got Justice Kavanaugh writing for the majority. Nope, we need to know for some reason on election night, even though in the midterms we learned weeks, if not months after other races, that that's the only standard that we have to go by. Was this driven by the law, or does it look at what it is, which is naked politics?
Well, it looks to me like naked politics, but we have to be careful. His decision does not hold that all the votes across the nation have to be tallied by midnight on election day. What he is saying is that in Wisconsin, if the vote isn't received by midnight, it won't be counted. That counting could certainly go on for the next day or two, however long it takes to count. So we got to be careful how we read the decision. He may say in dicta, it's called, not a holding, that he would like to say any vote not counted after midnight won't be counted. That's not what it says. It says it has to be received by midnight in order to be counted.
But as you know, Judge, Pennsylvania's case, which was 4-4 before obviously the confirmation of Ms. Barrett, there's a lot of folks on the conservative side wanting the Supreme Court, the reconstituted court, to rehear that case as well. And in that case, you had Judge Roberts ruling with the liberals to uphold basically what happened at the state level, to say, no, we're gonna count all the ballots as long as they were rightfully mailed in and sent in and received before Election Day. Is it possible what happens in Wisconsin doesn't stay in Wisconsin?
That's possible, but it's only Pennsylvania that I know. So right now, Pennsylvania's ballots can be received up to 3 days after Election Day and still be counted. There's a strong possibility that they will be able to get back to the Supreme Court on that case, and that Justice Barrett will make the difference. So we'll see.
To this end, we view, at least we used to view, and obviously we know the lens of the makeup of the 9 justices who nominated them politically, and we had an idea of where they were. In my lifetime, I don't remember the court being viewed in a prism the way we're looking at it now, where you could have 6 justices, 5 justices, if you excuse the Chief Justice for the moment, that could be so out of step with where the mainstream of America is, not just in terms of interpretation. We saw in the confirmation process the idea of where Roe could be perceived, about possibly gay marriage, with the Affordable Care Act, all issues where 2/3 or more of the American public strongly supports keeping them on the books. To say nothing of, to have an election potentially that's overwhelming one way, but the court deciding where votes can and can't count. Can you remember a time in recent history where the court is being viewed almost like another political arm?
No, I can't. And partly it's because justices have sometimes surprised the party that appointed them. So Republicans have appointed 16 of the last 20 justices of the Supreme Court. That's an enormous percentage, more than 3/4. But some of those appointees turned out to not vote in the expected way. Those days are over. The vetting now is completely political and ideological. So when you get a Justice Kavanaugh, a Justice Gorsuch, and a Justice Barrett, I don't think we're in for any surprise switches there.
You know, Your Honor, I, for one, at least in the beginning, was really uncomfortable. I understood the anger from a lot of, not just progressives, but folks who said, wait a second. I remember what happened with Merrick Garland. We couldn't even have a hearing on the guy. And now all of a sudden, with the passing of Ginsburg, we push Barrett through. Rank hypocrisy. I got it. And then they talked about packing the courts. And I said, you know what? We are destroying norms so casually now, I felt uncomfortable. But with what is going on in what is supposed to be a free and a fair election, potentially some of those hot button issues that I just mentioned before, I don't know. I don't think it's as crazy an idea and an unwarranted an idea. And historically, we have added justices. I believe Lincoln added justices. I know FDR had discussed it at one point. Are you nervous, though, that it becomes an arms race at a certain point as to where the Supreme Court goes? Because the American public should believe that the highest court of the land looks on things as its merits and whether it's lawful or not which political party suggested it.
So I don't think we should use the word court packing because it's a pejorative term. But expanding the court, as you said, has historical precedent. It's perfectly constitutional. The Constitution doesn't mandate a particular number of justices. And given the history that you just began to recount, the way that the nomination made by President Obama was treated, that is Merrick Garland, we were told it's too close to an election to confirm anyone, so we won't even have a hearing. That was 9 months. Now that it's less than 1 month, it's suddenly okay to do it. And I think this wrong has to be righted.
Judge Scheindlin, appreciate the time. Thank you so much.
You're most welcome.
All right, everyone. When we come back, as the president continues to downplay COVID amazingly, and several states at the same time seeing record numbers of people in medical centers, some cities are getting overwhelmed with cases and they're opening up field hospitals. Plus, hundreds of thousands of Americans suffering long-term health issues after getting the virus. They're called long haulers. One of them, she'll tell us her story after the break.